So we need to talk about some critical decisions which struck down a state's rifle and magazine ban, and those decisions are now up for appeal. Now, really quick before we jump into this video, I just want to mention that looking at some of my analytics, about 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. Also click the bell icon and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. As I mentioned in the intro, in this video, we need to talk about what is now happening in the critical cases challenging the state of Illinois' ban on so-called assault weapons and then also their magazine bans. Recently, we received a ruling from Judge McGlynn, the district court judge, and he struck down the Protect Illinois Communities Act, also known as PICA. This all came after the Supreme Court recently denied emergency review in a bunch of these Illinois rifle and magazine ban cases. Now, despite that denial by the Supreme Court, the judge here, Judge McGlynn, in all of these cases decided to move them forward to a final merits decision. And then recently he issued a decision striking down the PICA law, this rifle and magazine ban. He struck it down entirely as a violation of the Second Amendment. Illinois has now appealed that decision in all these cases to the Seventh Circuit. And once again, the biased Seventh Circuit, a 3-judge panel, decided to grant the state's request to put a stay on that decision. The Seventh Circuit also notified Judge McGlynn that they believed Judge McGlynn's decision was improper, that maybe there were errors, and they directed him to revise and essentially alter his decision to address some of those issues. Judge McGlynn has now issued that revised decision, and now this case is moving forward at the Seventh Circuit Court of Appeals level. Now, you might remember that originally in multiple of these cases, a district court issued the preliminary injunctions that were requested, and essentially those were intended to at least halt the enforcement of PICA before it fully took effect. However, the state of Illinois quickly appealed also those preliminary injunctions to the Seventh Circuit, and on review, again, the liberal and biased 3-judge panel in the Seventh Circuit overruled the granting of those preliminary injunctions. Now, in coming to those decisions, the Seventh Circuit concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they use something known as the military use test, which again, in my opinion, does not align at all with what the Supreme Court said in Bruin, Rahimi, Heller, or any of their precedent. That then led all of these cases for the first time to seek immediate Supreme Court emergency intervention. But like I mentioned, the Supreme Court at the end of their last term denied emergency review to all of these Illinois cases. But also in that denial order, you did have a statement from Justice Thomas, and he stated that if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied emergency review to these cases, Justice Thomas did make a statement, and he stated that there was an interest in this type of case if it reaches a final merits. Now, while those preliminary injunction appeals and the emergency Supreme Court cert was going on, the lower court judge here, Judge McGlynn, was moving these cases to a final judgment. Recently, there were oral arguments that were held in this case, and then a decision came from Judge McGlynn, and once again, he found that PICA is unconstitutional. It's unconstitutional under Bruin. It's still unconstitutional under the Seventh Circuit precedent, and therefore he struck down PICA in its entirety. However, in that decision, he did decide to temporarily stay the enforcement of his order for 30 days so that the state of Illinois could appeal to the Seventh Circuit and then also seek a more permanent stay from the Seventh Circuit if they wanted to. Of course, Illinois did appeal to the Seventh Circuit, and they also requested a stay from the Seventh Circuit. They wanted to halt the entire enforcement of that ruling by Judge McGlynn. Essentially, they wanted to still to be able to enforce PICA. Now, in their motion, the state of Illinois argues that the district court for the second time in 2 years entered an injunction prohibiting the enforcement of Illinois statute on a statewide basis. The court's decision is badly flawed, and the injunction should be stayed pending appeal. The opinion below fails to faithfully apply this court's decision in Beavis. It cannot be squared with the Supreme Court's precedent or the uniform decisions of the Court of Appeals applying such precedent, and it would threaten public safety by permitting military-grade weapons to proliferate again in Illinois. So the state of Illinois' primary argument is that the judge here, Judge McGlynn, misapplied Bruin and the Seventh Circuit's decision in Beavis, and also it would be such a public risk to have these types of weapons on the streets. Now, one of the interesting things also with this appeal and the request for this stay is that the state of Illinois maintains a very hardline approach with these rifles and magazines, saying that they are not arms at all, and therefore they're not protected at all by the text of the Second Amendment. And that's also despite the fact that they still acknowledge also in all of the briefs that these types of firearms and these magazines are owned in the millions by law-abiding people, not just in the state of Illinois, but all over the US. So they're clearly in common use, but still the state is arguing that they're not protected arms. Now, on review, the Seventh Circuit panel agreed with the state of Illinois and decided to grant a stay on the Judge McGlynn ruling. Also important was the development that the Seventh Circuit believed that Judge McGlynn's decision was actually deficient, that there were errors, that it was not expressly clear on the type of relief it was granting or who the judgment was in favor of, and maybe what defendants were barred or enjoined from doing certain things. So the Seventh Circuit was saying that, Judge McGlynn, we believe your decision is deficient. We want you to revise it, to change it, and to enter a new decision. In the Seventh Circuit's order granting the stay, the court also not only blocked the ruling, but they also directed Judge McGlynn to revise his prior decision. In the order of the Seventh Circuit, they stated that the defendant's request for a stay rests largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunctions. A decision at the preliminary injunction stage is not dispositive when the plaintiffs seek later permanent relief. Our opinion indicated some matters that needed further exploration, but the analysis in Bevis shows that the laws have enough support to remain in place pending the final resolution of plaintiff's suit. Every other court of appeals that has addressed the validity of similar legislation in the wake of Bruin has come to the same way in the same conclusion as Bevis. So the Seventh Circuit found that since they prior had ruled and upheld this type of restriction in the state of Illinois, and since other circuit courts have upheld similar rifle magazine bans, the state ban here should remain in effect until the Seventh Circuit appeal is resolved. They also told Judge McGlynn that his prior decision was deficient and they expected him to essentially revise it. Now, we also just got that revised decision from Judge McGlynn, so he heeded the Seventh Circuit's warning, I guess, and decided to clarify his decision, even though I think it was pretty clear before, but it seems like the Seventh Circuit was being nitpicky and wanted him to change his decision. Now, in the revised decision, he stated that this court holds that the Protect Illinois Communities Act is unconstitutional in accordance with the Second Amendment to the United States Constitution as applied to the states by the 14th Amendment of fact and conclusions of law, and that the permanent injunction is required to protect the rights of citizens of Illinois. He then granted a declaratory judgment and permanent injunction in favor of the Barnett plaintiffs, the Harrell plaintiffs, the Langley plaintiffs, the FFL of Illinois plaintiffs, and then all of the other organizations and parties that were attached to each of those cases. He then entered a decision enjoining the state defendants here from enforcing the PICA laws expressly against those various plaintiffs. So he just had to go through one by one, list directly that, of course, this law is blocked, that PICA is unconstitutional, and that the defendants here are expressly prevented from enforcing those laws against the defendants. Now, really, does that matter that much? The Seventh Circuit was, for some reason, being super nitpicky and was trying to find some sort of deficiency with the lower court decision. Now, in reality, this is still out of the hands of the lower court. It has now moved to the Seventh Circuit's, court's hands, and now they have issued the stay on that lower court decision, and they have full control of this case now. Some may think that the best option now is for the plaintiffs to then seek or maybe want an emergency review from the Supreme Court to remove the stay, but right now I think that that would just be denied. I think the best strategy as of right now would be to try to move this case as fast as possible through the Seventh Circuit process, through the three-judge panel, maybe even try to bypass the en banc and go directly to the Supreme Court, because we all know how the Seventh Circuit is going to rule on this case. Also keep in mind there is still hope for the Supreme Court to maybe grant review to a similar rifle ban case, the Snope case out of Maryland. That is a final merits case dealing also with the military use test, coming out of a Fourth Circuit en banc panel ruling that is currently seeking Supreme Court review. The hope really is that the Supreme Court will finally take up a critical rifle ban case this term. And of course, if they do and rule on that, that would impact the Seventh Circuit cases here. It would impact the state of Illinois' ban, California's ban on rifles, New York's ban, any state that has a rifle ban, it would directly impact that. But as we get more developments, as things change in this, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. But as always, thank you guys for watching. Don't forget to like and subscribe. But never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.